And that is increasingly a tool that the courts are looking to in eDiscovery, especially in other courts. I was in the process of litigating an issue where, whether or not, on a subpoena, the other party not agreeing to a clawback agreement, that became a big issue in terms of their argument for cost shifting. It was a subpoena, they wanted a cost shift. I was like, well, we would agree to a clawback agreement. We're a quick peach agreement. They're like, no, we're going to do this linearly. We're like, well, we're not paying for that. And the court agreed that we weren't going to pay for that. So, these are things that you just have to keep in mind.
All right, moving quickly on to production, there are just a couple of things that I want to mention here. Rule 34B2E states that absent court order, production in the form of which the data is ordinarily maintained or reasonably usable format is the way to go. Now, if you've had a conversation with the other side and you're meeting for a conference or later, if they've requested something different in writing, make sure you adhere to that request in production. Practically speaking, that's a native format. One thing to mention though, if you're producing a native format and you're receiving that data in native format, so I mean, if someone is giving you an Excel spreadsheet or if they're giving you Outlook database files, make sure that when you do your review, you don't just simply open up that document or open up that database file right there in Outlook. Because what that's going to do is alter all the metadata that's affiliated with it. So when you're reviewing native data, make sure that you're using a tool that keeps that metadata intact so it can help your case. You don't want to be unknowingly altering the data of the stuff that you're looking for. You're going to lose all that juicy detail. So I think that's it on this one. Right?
Yep. Okay, so big question. So to be or not to be. Are you going to use native or are you going to use non-native data production? And that's something you need to discuss right up front with the other party. In your Rule 26 conference, and I do refer to the federal rule a lot because it's more defined there. And there are some cases where you're going to want native data. If there are issues where maybe a fraud case or maybe a state case where there's a dispute over the modifications to a will or a trust or something like that, then you may want native production because you can keep track of the edits, you can keep track of the changes, you can potentially keep track of all sorts of things. Okay, 1 minute, so I'm getting really fast.
I want to get more tips.
All right, so yeah, but I mean the other reason, and then if you use non-native, that's fine. It also goes into whether or not there's going to be cost sharing or whatnot. Okay, so who pays for it? The short answer is it depends. Under the rules of civil procedure, the presumption is that the party who is responding to a discovery request bears the burden of complying with the discovery request. There is a big caveat, however. There's a seven-factor test for determining whether or not you can shift costs. And this is in descending order from what I listed here. And I'll just list it out. It's on the slides. You can see it later. If you want to read it more, look at the Super Lake opinions. This is, I can't remember what Super Lake is in. Super Lake 1. So, presentation.
Presentation, this is when you're going to present the data in court. And the things to consider are authenticity, chain of custody, whether it is an invisible duplicate. With data, you can't necessarily provide the actual document. So you need to have an invisible duplicate. Generally, that can be validated by its hash value. Again, we can go into that. Send me an email and we can talk about hash values if you need to. But generally, that's going to help get that document in. And also consider expert testimony, helping you explain to the court, whether it be in a hearing or in trial, to explain where the data came from or why it would be overly burdensome to get. So think of those three things.
Yep. Can I go through the I would love to tell you a story, but I don't. So attorney tips. Number 1 tip, be sure to keep track of your chain of custody. That's important because it helps you to keep track of the data and it helps as the invisibility. Keep track of your chain of custody as the data. Number 2 tip is linking, be sure to link the data to the author. Be able to and find some way to do that. Now, having good chain of custody can do that. There are other ways we can do it as well. There is a case out of Texas called Campbell v. State, where it says you can use circumstantial evidence to determine whether or not to link the evidence back to the author. And one of the ways that you can do it is even through distinctive speech patterns. Third tip is make sure that you are able to authenticate the data that you are going to present in front to the court. And accuracy can be impaired in any number of ways. There can be mistakes with data entry, mistakes in output. There could be programming errors, damage and contamination of the media, power outages, equipment malfunctions. These things can all impact the integrity of the data that you want to utilize. So make sure that you figure out and do your best to make sure that you can authenticate the data. There are a third tip, hearsay issues. There can be issues with hearsay and eDiscovery. The general consensus, though, is that if it's for example, if it's an electronically generated report, doesn't count as hearsay. Fourth tip, the original writing rule. There is the original writing rule. It does apply to eDiscovery. However, FRE 1001 sub 3 has helped really alleviate that problem. And then, fifth consideration, and this is an ethical consideration, and it applies specifically to social media. When you are representing someone and the adverse party has a social media account, don't friend them. You can't use deceptive friend requests as a way to get data that you otherwise wouldn't necessarily be able to get because of the privacy settings on that other party's social media account. If it's public, absolutely you can go after it. And if you're you will have some authentication issues there and some hearsay issues there, but you can prevent that. Right? But don't have yourself or someone working on your behalf create a deceptive friend request because that's potentially sanctionable behavior.
And very quickly, the expert tips. When you recognize that the case in front of you involves data, whether it's just a little bit of data or it's big data, these are the tips that I want you to think about. Anticipate and be proactive. In doing that, you're going in the long run to save your clients some big money. Number two, communicate and cooperate. When you're working with companies, make sure you bring in all the heavy hitters that understand what's going on with that company. That's the best way to figure out how to get to the meat and potatoes of what you're looking for. In addition, bring in experts to help you out. Help them educate you to wade through that big data case. It's not as bad as it seems, especially when you've got someone on your side that can help hold your hand a little bit and point you to the good stuff. Number three, don't assume. Don't assume that the other side understands what you're asking for. Put it in writing. Don't assume that your client understands what the word reservation means. Don't assume that just because you sent out the litigation hold once, that they're going to remember to do it a month from then. Always follow up. Always make sure that people understand what you're talking about, because at the end of the day, you're the one standing in front of the judge. And you want to be able to say, Your Honor, I did everything that I possibly could to help them understand. Number four, always ask yourself, when you're handling data, is this defensible? Am I handling this properly? Am I making sure that it's in a forensically sound manner? Make sure that it's an audible, repeatable process. And finally, kind of tying all that together, again, document everything. That's going to help make your case in the long run. So we went over a little bit. I apologize. Again, write down questions or things that you want all of us to cover at the end. If you have any questions, shoot me an email or call. I'm super happy to help you out in any way, shape, or form. Thank you so much, you guys.
Yep, I'd like to say thank you as well. And I've been told to shamelessly plug the Sioux Falls Green Project. Their cups, they're outside. Beth Overwell has them. They're doing a great job, so be sure to get some cups.
Thank you again to Bob and Colleen. And just as a reminder, they will be on the panel, so if you have questions, keep them in mind, and we'll be out in the audience so that you can ask them all of your questions. We're going to take a short break now, so if you can try to be back and in your seats at 10 o'clock so that we can all listen to Judge Schroeder.